My name is Andrew Campanelli. I'm an attorney. I've been a litigation attorney for 27 years. For the past 2 decades, I've handled cell tower matters across the entire United States. I'm admitted to federal courts in something like 23 states. And the Telecommunications Act of 1996 is something I handle every single day. I handle cell towers every single day. And if I'm speaking quickly, it's because I have to appear before another local zoning authority at 7 o'clock this evening, so my time is very short. Local governments come to me on a regular basis to help them amend their zoning ordinances to vest them with the maximum power to control the placement of wireless facilities in their jurisdiction. Unfortunately, most of what local governments have heard about the Telecommunications Act of 1996 is false. I'll tell you specifically what I'm referring to. Pretty much everything you've heard about the Telecommunications Act, I'm willing to bet, refers to subparagraph B of the Act. See, the Telecommunications Act of 1996 contains 2 main subparagraphs. One is 332C7A and one is 332C7B. When Congress adopted the Telecommunications Act, it considered giving the FCC the power to control where wireless facilities go. At the end of the day, they did the opposite. The very first paragraph of the Telecommunications Act is entitled General Authority, and within that provision, Congress preserved to local governments the general authority to control the placement of wireless facilities within that jurisdiction. Based upon that grant of power by Congress, for the past 24 years, local governments have enacted and enforced local zoning ordinances to control the placement of wireless facilities. They enact what are called smart planning provisions. These are provisions designed to achieve 3 objectives. Number 1, to enable carriers to saturate jurisdictions with wireless coverage, while at number 2, minimize the number of facilities you need to provide that coverage, and number 3, avoid to the greatest extent possible any unnecessary adverse impacts upon residential districts and residential properties. And that's worked fine for 24 years to the extent that sophisticated governments have drafted zoning ordinance that enable them to do that. But the only thing you hear about are the provisions of subparagraph B. Those contain 5 finite constraints imposed upon those powers of local governments. But as long as you know how to enact an ordinance and enforce that ordinance, you still have the power to control where these things go. Now, I've heard someone say that you can enact a 16-foot setback requirement without violating the Federal Telecommunications Act of 1996. If anybody made that blanket statement to you, they have no idea what they're talking about. They don't have an understanding of subparagraph A and of greater import, the interplay between subparagraph A, the Telecommunications Act, and the rulings of the United States Circuit Court of Appeals for the First Circuit, which governs federal courts in the Commonwealth of Massachusetts. Now, I admit I'm not admitted to the state courts of the Commonwealth, but I have been admitted to the district court. I'm also admitted to the First Circuit Court of Appeals and 9 of the 13 circuit courts in total. So here's how it works. You have the power to adopt any setback ordinance you want, okay? And you have the power to handle applications under your zoning ordinance. However, to do that, you must do 2 things. Number 1, you have to have a process by which someone can seek an exemption from that restriction. What does that mean? One of the finite limitations that the Telecommunications Act places upon local governments is that if someone needs a wireless facility to be installed and it's the only place they can install it, then even if it violates your code, you must let them do that. Now, that's a very narrow exception, and I'll tell you specifically what it means. One of the provisions says you can't effectively prohibit the provision of wireless services. Now, what that means is, let's say for argument's sake, you adopt a setback limitation that says you can't put a cell tower within 1,600 feet of a residential district. Suppose an applicant comes in and says, you must let us put one within that distance, because if you don't, you will effectively prohibit us from providing personal wireless services. You must have a procedural mechanism through which one of your local zoning boards can entertain an application to determine whether or not a denial would be an effective prohibition. Now, the standard in the First Circuit is very narrow, and local boards have the power to make the factual determinations to figure out if they meet that standard. Because if they don't meet that standard, you don't have to let them put it in. Here's how it works. For an applicant to claim under the Federal Telecommunications Act of 1996 that denying their application would effectively prohibit them from providing personal wireless services, they must prove to your local zoning board 2 things. Number 1, they must prove that they have a specific carrier has a significant gap in personal wireless services at the specific location where they want to put the tower. Number 2, they must prove that their proposed installation on the site they want, on the specific section of the site they want, and at the specific height they want is the only feasible means of remedying the gap. In 98% of the cases I've seen across the entire United States, they can't meet that standard. Now, who gets to determine if they've proven those two factors? Well, if you're put in your local zoning code that one of your boards get to make those factual determinations, then they get to make those factual determinations. If you say your planning board gets to make them, they get to make those determinations. Not only do they get to make those determinations, they get to decide what evidence they can require the applicant to produce, and they alone get to determine the weight of the evidence. And under the standard of the First Circuit, the applicant has to prove to that board that there's no possible alternative locations. They've exhausted a thorough analysis of every possible alternative location, every shorter tower. And that's not my words. Those are the words of the United States Court of Appeals for the Second Circuit. I'm going to give you a case citation. You can look up, if you're any attorneys on here, look up Industrial Tower and Wireless LLC versus Haddad. The citation is 109 F sub 3rd 284. It's a 2005. Well, they will have adverse impacts on your zoning districts, okay? Cell towers should be treated just like any other public utility, okay? They're a necessary evil, no less necessary than a sewage treatment plant. But just like a sewage treatment plant, you don't allow sewage treatment plants in residential districts. Why? Because the use is considered incompatible. For the same reason, you can deny the installation of cell towers or other wireless facilities in residential zoning districts. Every day across the entire United States, I have cell tower applications denied because of adverse aesthetic impacts on residential properties, because the cell tower is out of character with the neighborhood, because it'll reduce property values, because it has an insufficient fall zone. There are 20 different grounds upon which you can deny an application for a cell tower. The key is you must codify those grounds in your local zoning code. The Telecommunications Act does not provide grounds for denying applications. Your local zoning code can, as long as you codify it. In addition, you must codify your legislative intent. Mr. Connell pointed to some reasons why you want a 1,600-foot setback. By way of example, because you can find that the installation of a 15-story tower in a residential district is an incompatible use. That's perfectly proper. You cannot, however, put in your code that you want to keep it away for health concerns. That's not permissible. But you can and should add in the legislative intent section of your code, the legislative intent for which you adopt a 1,600-foot setback requirement in the first place, meaning the types of adverse impacts you want to prevent, which is the reason why you're adopting the setback requirement in the first place, to avoid adverse aesthetic impacts, reduction in property values, preventing incompatible uses that are out of character in the neighborhood. If you do it the right way, you are well within your power to impose this setback requirement, and greater than that, you then have the power to make fact-finding determinations. Has an applicant proven that an identified carrier has a significant gap in service? You have the power to review whatever evidence they submit and analyze what weight should be given to that evidence. You have the power to demand that they give you probative evidence, not things like propagation maps without any supporting data. If an applicant claims to have a significant gap in a specific area, you can demand hard data. You can demand drive test data, which would show you if there's a gap, exactly where it is, the location of the gap, and the geographic boundaries of the gap. Because if and only if you get that hard data, it then places you in a position to ascertain if there's no other possible site that can remedy whatever gap exists. So the key is informed drafting of your local zoning code. I do it all day long, every day. That's the key. So if anyone tells you can't have a 1,600-foot setback as a matter of law and you'll violate the code, the Telecommunications Act, they don't understand the Telecommunications Act, period. In addition, let's say for argument's sake, somehow you violate the Telecommunications Act and you get sued. I tell local governments every day, so what? If a wireless carrier sues you and somehow proves that they violated the Telecommunications Act, you don't pay them a penny. According to the United States Supreme Court under the Telecommunications Act and 42 U.S.C. 1983, they cannot win damages and they don't get attorney's fees. So if you get sued and lose, the only thing you have to give them is the permit to build the tower. And the only time you get sued and lose is if you don't draft your code the right way, You don't teach your local zoning board what fact-finding determinations they have to make, and you don't apply them in a manner consistent with the code. I have a few minutes left. I am sorry for throwing so much information at you so quickly, but as I mentioned, I have to be at appear before another jurisdiction shortly. I would welcome any questions you have. Again, I've been doing this for 20 years. I've handled 7,000 cases. I can pretty much answer any question you might have. So if any board members have any questions, please ask them now.
Is there anyone on the board who has a question?
Is anybody still awake? If you're not awake, put your head down and sleep.
No, we're always awake.
Great, I appreciate that. Okay, well, listen, I'm available. I do speak to local board members for free. I'm gonna give you my phone number. My phone number is 516-746-1600. If any board member has an individual comment about the Telecommunications Act or what you can and cannot do, I take phone calls. I don't charge you anything. Thank you very much. Have a nice evening. I'm off to another jurisdiction.
Thank you.
Thank you very much.